Well, good morning to all of you. Thank you for joining us. My name is Bob Nichols. I'm a partner in the Labor and Employment section of Bracewell. I'm here in Houston. I'm joined by my longtime colleague, Amber Dodds, who works from our San Antonio office. Amber and I have worked closely together, and both of us have devoted our practices exclusively to the representation of employers in labor and employment matters. I've been doing that for 32 years, and Amber's been doing that for almost 10 years since leaving the University of Texas Law School. Amber and I have had the opportunity to work closely and carefully on a lot of employment projects, but she and I in particular have devoted a lot of time to OSHA work. So we've had many hours poring over materials on such interesting topics as lockout, tagout, permit required confined space, process safety management, etc. And we've spent a lot of time working with OSHA officials. And a question that's been posed to us particularly a lot in the last 9 years, and I'll explain why the last 9 years, has been what are the legal concerns associated with our company providing bonuses or other incentive compensation based upon some designated low level of reported or OSHA recorded injuries and illnesses in the workplace. That has been a matter of major concern for OSHA, particularly in the last 9 years. Again, we'll explain why, and we'll tell you the story of how we got to where we are now on the issue of injury rate-based incentives. And we'll talk about where we're headed. A couple of logistical matters. We urge you to offer any comments or questions you might have. You'll see in the corner of your screen a box where you can type in messages, including questions. We won't have time to answer questions during the presentation, but I promise either Amber or myself will answer every question posed either by email or phone call sometime after our presentation. With that said, I want to turn to Amber to explain to all of you the background that led OSHA in particular to be concerned about the impact of incentives tied to workplace injury rates. Amber, could you tell our folks today about the GAO and their role in this story?
As Bob noted, the history of safety incentive programs is long. For this webinar, we start with an October 2009 Government Accountability Office report issued to congressional requesters. Those requesters, noting the 4 million employees who were injured or became ill at work in 2007, sought information on what efforts the Department of Labor, through OSHA, used to ensure that injuries and illnesses were properly recorded. The 2009 GAO report recounted widespread underreporting of workplace injuries in the United States, based on interviews of numerous levels of agency officials, academics, researchers, labor representatives, worker advocates, and thousands of occupational health practitioners. The report determined that a substantial number of recordable workplace injuries were not being recorded on OSHA 300 logs. As to why, report authors determined that, among other factors, employee, quote, fear of jeopardizing rewards based on having low injury and illness rates, end quote, affected injury and illness reporting. As a result, the Government Accountability Office called for OSHA to act to address that underreporting. I'll turn to Bob to discuss OSHA's response to that call.
The response that Amber refers to began with a memorandum from an OSHA official named Richard Fairfax. He's a significant figure in my career because I talked to him repeatedly over the years when I could reach him about OSHA questions we had for clients. He has an interesting personal story that gives him a sense for the realities of injuries in the workplace and injury reporting. Mr. Fairfax began his career not in college, but as a pipe fitter welder, working in refineries, particularly in Pasadena and Texas City, Texas. In 1977, he went to work for OSHA as a field compliance officer. He very impressively worked himself up through the ranks over the years. And by 2010, he was actually Deputy Assistant Secretary of Labor in Washington, D.C., overseeing, among other activities, all OSHA enforcement. Very bright and practical man, and a key figure in 2012 with regard to enforcement decisions by OSHA. In that year, 2012, Mr. Fairfax issued a memo to OSHA officials, a directive of sorts, that received a lot of attention. Specifically, Mr. Fairfax, probably in part in response to at least the GAO report that Amber referred to, issued a memorandum about retaliation and record keeping pursuant to OSHA requirements. As many of you know, OSHA prohibits retaliation against employees for virtually any conduct related to safety. You see it on this slide, the language of Section 11C, but let me emphasize that any employee report, complaint, or concern raised orally or in writing, either internally or at the company or with an external agency, i.e. OSHA, is automatically protected activity under Section 11C, and therefore you cannot punish employees in any way for raising concerns about safety or health in the workplace. One key issue that Mr. Fairfax addressed in his memo in 2012 was that it's the agency's position that any employee report that they have been injured or fallen ill because of a workplace condition automatically constitutes protected conduct under Section 11C, which was very interesting because many of our clients for years had been dealing with what we call workers' comp retaliation lawsuits brought under state law, where employees said they were punished for reporting injuries or filing claims. And that conduct, that kind of retaliation, is unlawful in all 50 states under state law. Well, now Mr. Fairfax said OSHA viewed that as unlawful retaliation under the Act. You may ask, well, if there are already state laws prohibiting retaliation for injury reporting, why did Mr. Fairfax's memo matter? Well, first of all, it meant now it was not only the prospect of a state court lawsuit, but it could be an OSHA whistleblower, investigator, or compliance officer inquiring into your practices with regard to handling employees who report injuries and perhaps requesting documents or interviewing employees, including non-supervisory employees in private. So Mr. Fairfax's action definitely upped the ante on the notion of punishing employees for reporting claims.
Fairfax in his memo, as Bob noted, set out the agency's position that reporting a work-related injury or illness is a core employee right. The memo went on then to address what Fairfax described as, quote, several types of workplace policies and practices, end quote, that could be considered unlawful retaliation against employees for engaging in that protected right. First, and we did not include that on the slide, Fairfax noted that employer policies to discipline all employees who are injured, regardless of the circumstances, is a clear and direct violation of Section 11C. That seems pretty straightforward. But other circumstances resulting in discipline may be less clear. For example, Fairfax warned that employers need to be cautious about punishing an employee for a safety violation after the employee reports an injury. While Fairfax noted that OSHA encourages employers to maintain and enforce legitimate workplace safety rules, there was danger that employers may use those rules as a pretext to discipline employees who report injuries. As to the key considerations before disciplining an employee who reports an injury, Fairfax posed these questions. Did the employer conduct a careful investigation before imposing discipline? Does the employer monitor for compliance with the work rule in absence of an injury? Does the employer consistently impose equivalent discipline against employees who violate the work rule in the absence of an injury? Further, when a work rule is vague, such that it can be manipulated to punish employees, Fairfax gives the examples of rules requiring employees to work carefully or maintain situational awareness as rules that can be used to punish injured employees. Another type of employer policy that Fairfax addresses is discipline for the failure to timely report an injury or illness. The Fairfax memo indicated that employer punishment of employees for not reporting an injury or illness within the time period provided by the employer's policy could, depending on the circumstances, violate Section 11C. In these situations, employers must consider specific circumstances of the failure to report, such as whether the failure to report was intentional or inadvertent, minor or extensive, and whether the employee realized that he or she was injured within the time period required to make the report. Fairfax indicates any discipline issued based on a failure to timely report is subject to what he referred to as careful scrutiny, because the act of reporting the injury directly resulted in discipline. Additionally, the rule must be reasonable and may not unduly burden the employee's right and ability to report the injury. This includes the rule being reasonable in terms of the time allowed to report and any punishment assessed for violating the rule. On our topic for today, the Fairfax memo did not declare incentives uniformly unlawful, but instead indicated, based on circumstances, that a program could violate the law under a variety of factors that result in employees not reporting their injuries. Fairfax, though, described rate-based incentive programs as either intentional or unintentionally providing employees an incentive not to report injuries. He was blunt in his assessment, stating that, quote, there are better ways to encourage safe work practices, end quote. Fairfax's view reflects a long-standing union view of the pervasive bloody pocket syndrome, which describes employer undue influence on employees who are injured to hide those injuries, such as an employee putting an injured and bleeding hand into his pocket rather than reporting his injury. Fairfax concludes the memo by stating if the incentive is great enough that its loss dissuades reasonable workers from reporting injuries, the program would result in the employer's failure to record injuries that it is required to record. OSHA incorporated this concept in its rulemaking just a few years later.
Thank you, Amber. One aside with regard to the Fairfax memo I want to mention, though we don't have the time to make it a focus of today's presentation, is that Fairfax emphasized, and OSHA has since emphasized, that they don't like blanket post-injury drug testing for some of the same reasons they don't like sometimes injury rate incentives. And that is that if an employee knows they're going to be drug tested, if they report they were hurt, that may dissuade reporting. Without spending a great deal of time on that today, let me just say as an aside, your company should not have blanket policies of drug testing everyone who gets hurt. Rather, your focus with post-accident drug testing must be on whether, given the individual circumstances, there's a reason to believe an individual may be culpable, responsible for an accident or injury, not whether they have been injured. If you take a blanket approach that everyone who reports they've been hurt gets drug tested, you might very well find yourself in trouble with OSHA at some point. With that said, turning back to our topic today, which is incentives, I remember when the 2012 memo came out, I spoke with a colleague of mine and Amber's. We both will work a lot with her, Amy Halevi, about the significance of his memo, because after all, it was just a memo. It wasn't a statute. It wasn't even a notice and comment regulation. So could OSHA effectively ban or largely ban incentive-based programs through a memo? And the conclusion we reached at the time was, well, they can't. But at the same time, we better not ignore what OSHA thinks, even if it's not black letter law. Well, in 2016, we saw OSHA go further, probably recognizing that the memo was not enough. In 2016, OSHA issued its final rule on electronic submission of injury and illness data to OSHA. And as part of that regulatory action, OSHA also bolstered its regulations having to do with retaliation and specifically emphasized in their regulations now that punishing an employee for reporting an injury or illness incurred in the workplace constitutes unlawful retaliation. Very significantly, in that 2016 final rule publication, there was a preamble that talked at some length about the agency's views of incentives tied to the rates of recorded injuries. And OSHA expressed the view that those were not viewed positively. Interestingly, the regulation language itself does not address incentives. It's all addressed in the preamble, sort of the preliminary explanation of a new rule that's issued. In that preamble, OSHA asserted, quote, "It is a violation for an employer to use an incentive program to take adverse action, including denying a benefit because an employee reports a work-related illness or injury such as disqualifying the employee for a monetary bonus or other action that would discourage or deter a reasonable employee from reporting the work-related illness or injury. The preamble went on to provide that, quote, in contrast, if an incentive program makes a reward contingent upon, for example, whether the employee correctly follows legitimate safety rules, rather than whether reporting any injuries or illnesses, the program would not violate this provision. Finally, the agency indicated OSHA encourages incentive programs that promote worker participation in safety-related activities, such as identifying hazards or participating in investigations of injuries, instances, or near misses. So the takeaway that we discussed at the time when this preamble was issued, again, it's a preamble. It's not a statute. It's not the language of the regulation itself, is that OSHA was sending another powerful message that they do not like incentive programs tied to low recorded injury levels, and that under some circumstances, maybe many circumstances, they could view such a program as unlawful under either the anti-retaliation provisions of Section 11C or the employer's obligations to keep records of injuries or illnesses as provided under other OSHA regulations. With that, let me turn things back to Amber, because the plot thickens with the departure of President Obama and the arrival of President Trump. Amber?
Thanks, Bob. As Bob noted, when the 2016 regulations were issued, we were in a difficult place. OSHA had not expressly prohibited rate-based safety incentive programs, but it had taken such a strong position, it was unclear whether OSHA would consider any rate-based program lawful. Then, in October 2018, the then acting director of enforcement programs at OSHA issued a memorandum to various OSHA personnel concerning monetary incentives. The memorandum opened with a direct, albeit lukewarm, answer, stating that, quote, the purpose of this memorandum is to clarify the department's position that the 2016 regulations do not prohibit workplace safety programs, end quote. This was certainly not a ringing endorsement of what the memo described as incentive programs that are rate-based and focus on reducing the number of reported injuries and illnesses, but instead just confirmed that such programs may be lawful if they stay within sufficient parameters. Specifically, rate-based incentive programs are permissible as long as they are not implemented in a manner that discourages reporting. Expanding on these parameters, the 2018 memorandum offered some explanation of how an employer could construct a lawful rate-based incentive program. As you will see in the quote on this slide, first, it may not be enough to simply encourage employee reporting, especially if that reporting will result in the loss of the incentive. Instead, additional positive steps are required to create a workplace culture that emphasizes safety beyond reduced rates of injury and illness. So what positive steps did that memorandum recommend? The 2018 OSHA memo recommended an incentive program that rewards employees for identifying unsafe conditions in the workplace, which could potentially include incentives for reporting near misses or other observations of unsafe working conditions. A training program for all employees to reinforce reporting rights and responsibilities and emphasize the employer's non-retaliation policy, and a mechanism for accurately evaluating employees' willingness to report injuries and illnesses. This list at least gave employers some concrete recommendations for balancing rate-based incentive programs with other affirmative safety measures. But how heavily can employers rely on that 2018 clarification today? Not heavily. The 2018 clarification was merely an internal agency memorandum. It only suggested that rate-based incentives can be lawful if properly structured and counterbalanced. And it came during the Trump administration, when OSHA's position on many policy issues was markedly less aggressive. The Biden administration, of course, is not legally bound by this Trump-era internal clarification. While employers may use the positive steps listed in the 2018 clarification to supplement their rate-based incentive programs, implementing these steps will not excuse what the Biden administration OSHA may see as an unlawful rate-based program. So, Bob, can you speak to President Biden's OSHA nominations as a prediction of what is to come?
Absolutely. And on this cover slide, I quote former Secretary of Labor under President Obama, Hilda Solis, who famously, when she took office at the start of the Obama administration and was particularly concerned about the vigor with which OSHA pursued enforcement, gave a speech in Houston where she declared, "There's a new sheriff in town." And Biden's picks for the Department of Labor, Secretary of Labor, and for OSHA have signaled once again that there is a new sheriff in town with regard to OSHA enforcement. The new Secretary of Labor, the nominee to head OSHA, the acting head of OSHA are all former labor, that is, union officials. And they have strong feelings specifically about these incentives we're discussing today. Let's first of all talk about the nominee to head OSHA, to be OSHA Administrator Doug Parker, a longtime union attorney and Democratic Party activist, University of Virginia law grad. His nomination has been approved at the committee level, and there will be a full Senate vote, and presumably he will be approved to formally serve as the administrator of OSHA and an assistant secretary of labor. Parker, like a lot of lawyers, is a prolific writer, and he has been very, very critical in writing for a long time of incentive programs tied to low recorded injury rates. Parker had previously written about the clarification that Amber discussed, and he was not complimentary in his characterization of that Trump administration clarification. He described that as an attempt to undermine the heart of the 2016 rule provisions by limiting enforcement to circumstances where it can be proven that the employer intended to discourage injury reporting. Parker has written that the 2018 clarification memo gives, quote, employers a roadmap for avoiding citations by adding superficial changes to their incentive programs. Parker, in an earlier writing, categorically insisted that rate-based incentive programs, quote, inherently discourage injury reporting, close quote. And that certainly sounds like an individual who does not regard incentive programs tied to injury rates as legitimate under any circumstances. And as we indicate on this slide, Amber and I cannot imagine that any pragmatic employer could think that Mr. Parker and the Biden administration are going to feel bound by the Trump administration's 2016 clarification about incentive programs. In fact, employers should expect that there'll be new OSHA directives and guidance that specifically attack rate-based incentive programs and finding them, if not always unlawful, often unlawful or unacceptable. Notably, Parker has not been the only Biden pick who has been highly critical of these incentive programs. Jim Frederick, a former steelworkers union official, now serving as acting assistant secretary of labor for OSHA, has previously warned that the problem does not just impact rank and file workers, explaining that, quote, well-meaning supervisors can be pressured to show fewer recorded injuries or find a new job, close quote. This raises an important question that some of you are probably thinking about, which is, Bob and Amber, when you're saying that incentives are a potential legal problem, are you only talking about incentives where rank and file workers are offered incentives? Are you talking about our incentive and compensation programs for supervisors, managers, even company executives? And the answer is all of the above. Consider, for example, what a Biden administration transition team member had to say, David Nichols, who was the former head of OSHA under President Obama. Dr. Nichols has previously warned that, quote, prizes, rewards, or bonuses to supervisors or managers that are linked to the number of injuries or illnesses recorded on the OSHA log represent a significant problem that OSHA needs to address. So you can see that the once again, the tide has turned politically and also from a regulatory perspective. I want to turn things back to Amber to talk briefly about how VPP participants are uniquely impacted.
If the history of the memorandum and the preamble and the writings Bob has been quoting isn't enough, let's look at how OSHA has treated voluntary protection programs, or VPPs. VPPs recognize employers who have implemented effective safety and health management systems and maintain injury and illness rates below national averages for their industries. OSHA has been especially skeptical about injury rate incentive programs for business establishments that participate in VPP. For example, following the 2009 GAO report, OSHA issued a revised internal VPP policy memorandum in June 2011, addressing how to evaluate incentive programs. Further, David Nichols, who Bob just mentioned, revised this memorandum in August 2014, stating that, quote, an incentive program that focuses on illness and injury numbers often has the effect of discouraging workers from reporting an injury or illness. Dr. Nichols concluded that a site whose incentive program has the potential to discourage worker reporting fails to meet the VPP's safety and health management system requirements. This memorandum was again updated in 2017 during the Trump administration. According to OSHA's August 2017 update, VPP participants that use a program that is rate-based and focuses on injury or illness numbers, quote, must be able to demonstrate what type of precautions are in place to ensure that the program does not discourage reporting. Separately, that memo reiterates that OSHA will assess the employer's program to ensure that it does not discourage reporting. Given OSHA's history of expressly reviewing VPP participant safety incentive programs, we can expect the Biden administration to put particular pressure on VPP participants to avoid or minimize these programs. I'm going to turn it back now to Bob for some guidance for employers going forward.
Thank you, Amber. So in preparing for this webinar, Amber and I talked about the fact, are we telling people they need to drop these programs? Are we telling employers they need to modify these programs? What is the message? And this is what Amber and I settled on. First of all, no employer can feel confident that the Biden administration and Mr. Parker and other officials will not just outright ban these rate-based incentive programs. They would like to, and they will measure whether they can legally, and they will express their hostility as this administration goes along, and they will issue guidance attacking rate-based programs. There's no doubt about that. If they're going to go so far as to make them unlawful, period, we don't know. And when communicating with your executive management, you certainly can make no promises as to whether any rate-based incentive programs will survive this administration. But we want to, with that caveat in mind, we want to focus on things you can do to make yourself less of a target, even under the Trump administration clarification and the things said by Mr. Fairfax in 2012. So let's talk about how you more safely structure a program. First of all, on an earlier slide, Amber listed the things, the counterbalance measures that the Trump administration called for if you were going to have a rate-based incentive program. You can look back on that slide and you should implement all three of those if you can, and if you want to maintain a rate-based incentive program, but you should go further. You also should have other positive safety incentive programs. You should have programs that will reward employees for raising safety concerns. You should have and develop other programs for people, for example, people who participate in OSHA safety committees, employees who provide other helpful suggestions related to safety, et cetera. You need to have behavior-based positive safety programs, especially if you want to retain some kind of rate-based incentive program at the same time. Never structure your program so a group of employees are all denied an incentive because one of the employees in the group reported an injury. That kind of program probably has an intended effect, and OSHA understands that and doesn't like it. They don't want that kind of group peer pressure placed on employees not to report injuries. So avoid the group dynamic if you're going to have an incentive program where, for example, a department may look unkindly upon a coworker who has cost them the end of the year bonus or has cost them the turkey at Thanksgiving. Make sure that the incentives, especially for rank and file employees and lower level supervisors and managers, are not large in value. And Amber and I have talked about the irony of this. If you look back to what Mr. Fairfax had to say and others have had to say, they seem to find rate-based incentive programs less objectionable if the incentives are small enough that they're not going to be effective. But the point is you shouldn't be offering really large incentives because then you're really ratcheting up the pressure on rank and file workers not to report injuries. While rate-related incentives for executives are viewed somewhat less suspiciously by OSHA historically than incentives for lower-level rank and file employees, even with executives, injury rate metrics should only be one factor among a variety of factors in assessing any bonus or incentive opportunity. For example, you want to avoid a situation where an executive's compensation is mathematically reduced based upon the level of injuries reported. You may say, why does OSHA care about executives? They're not, an executive, practically speaking, is not going to report an injury. It's because they understand the dynamics of organizations, which is some people, a manager, a plant manager, an executive who knows that their compensation will be adversely affected by reports of injuries might, in some instances, apply pressure downward on others in an effort to make sure they don't see those reports made. Train all managers and supervisors as well as executives that any pressure, subtle or otherwise, on anyone not to record an injury represents severe misconduct that will lead to discipline or discharge. Have policies, as you must, that tell employees that they have to report them. By the way, under OSHA regulations, you're supposed to have including the regulations that were adopted in 2016, you're supposed to have a mechanism, an easily used mechanism for employees to report injuries and illnesses, and you should punish anyone severely who seems to be applying any pressure on employees not to report. Safety personnel, plant nurses, other individuals who might be responsible for making recordability decisions ideally should not be participants in incentive programs tied to low levels of injuries. They have to make close calls sometimes on whether something is recordable. You don't want money coming out of their pocket because they make a decision that a particular incident is recordable. Educate your management again that under the current administration, they should never feel confident that this administration won't act against rate-based incentive programs generally. Finally, a caveat for some of you who have wide-ranging operations, beware of state-planned state agencies that take differing approaches. For example, there's been guidance issued by Oregon OSHA, which seems, as I read it, to effectively prohibit injury rate-based incentives. Other state agencies, like Cal OSHA, for example, might ultimately act in a similar manner, particularly if the feds don't take more aggressive action in their view against these programs. I hope our presentation has been helpful today. Again, please submit any questions you might have and have a super day. Thank you.